Welcome to Immigration Unpacked, real legal help for immigrants.
Hello and welcome to Immigration Unpacked, real legal help for immigrants with Kevin J. Stewart. Kevin is a dedicated immigration attorney committed to helping individuals and families across California and beyond. I am your host, Kevin Rosenquist, and today's episode is all about the business of immigration, navigating employment law for foreign workers. Kevin, welcome back.
Yeah, great. Thanks, Kevin.
I'm glad I didn't scare you away after the first one.
Yeah, no, I'm looking forward to this.
Yeah, for sure. All right. Well, let's start here. Can you explain the intersection between immigration law and employment or business law?
Great question. Businesses are mainly regulated by state law generally. And so the idea is that you have to obviously follow tax laws. You have limits on who you can employ. You need to verify that people are authorized to work in the U.S. And then people are at-will employees, or in some cases, kind of limited cases, they have contracts. So that's the whole field of employment law. And in immigration, the most visible connection there is having lawful status to work in the U.S. So, and there's a whole range of ways that you establish that. People have probably heard of the I-9 form. Employers have to get an I-9 from everyone they employ, and that requires you to present some form of evidence that you're authorized to work in the U.S. So it'd be birth certificate, social security card as a citizen, or if you're an immigrant, you work permit or visa that would allow you to work.
How do these two areas of law work together to help employers and employees?
The help for employees in employment law is mainly anti-discrimination, laws that protect worker safety, these types of things. And actually, it helps employees to manage who can and can't work in a company. I mean, even though we all know about certain industries that have a certain number of unauthorized workers in terms of immigration status, we know that it's actually better that is managed. That's sort of the employment law side of it. Immigration law helps employers in setting certain standards for people who can hold certain jobs. Just to give you an example, in H-1B, there is you have to file with the Department of Labor. You have to file a labor certification application. And so the LCA determines what is the minimum wage that can be paid to a foreign worker. So essentially that protects all workers, protects U.S. workers from being undercut in terms of what can be paid. That's a common misconception. People think, these H-1B workers, they're getting lower pay. Generally, that's not true. Certainly, it's not true in an area like the Bay Area.
Okay. And what are some of the big challenges you see businesses face when hiring foreign workers, and how does immigration law help or impact their hiring practices?
Yeah, it can be expensive, and it's gotten very expensive, I have to say. The fees that are charged on top of what it costs just to bring a worker, I mean, just off the top, it might cost you $10,000 in fees and reasonable attorney fees. I mean, if you're a large company, like a large tech company, like a Google, somebody like that, if you hire a major immigration firm to handle it, it's millions of dollars a year. Yeah. Oh yeah. To have the resources to do it. So the
good news is Google's doing okay. So
yeah, I mean, this is the thing. It's, when people call me, they call us, me or my team, usually it's the employee, or it's a startup. It's an entrepreneur who, doesn't have access to big law to do their immigration work. And I mean, I dare say that we give them better service.
I mean, yeah, you think that happens a lot, like you have a smaller practice and you have maybe a little bit more of a white glove service or a hands-on approach, I would think.
Yeah, I mean, we're actually available. I mean, it's obviously part of the thing with big law is just that. I mean, they're handling hundreds, thousands of cases. But the thing is that for us, we get to know the business. For example, in the Bay Area right now, AI startups, San Francisco particularly, I mean, that's the thing. That's what people are doing. But it isn't just AI in terms of software and technology. It's like, what are they doing? What are they building? And how is that adding value? And those are the things that help us to get people over the applications that they're submitting, because we're able to show, hey, this is actually going to benefit this project that they're working on, this business that they're starting.
When a company first decides to hire a foreign worker, how do they determine what visa is the one that they should be using?
Yeah, no, that's a great question. So there are two aspects. If you have someone who's already here in a non-immigrant status, I'll give you a couple of very common situations. One is you have someone who was here on a F1 student visa. They've finished their program. They're in what we call occupational practical training. So OPT allows them to stay technically in the student status, but now allows them to work, because normally under their student status, they can't. So we help the transition between that OPT status and another status, for example, H-1B or O-1A. So they're still in non-immigrant status, but the restrictions of their previous status, they no longer have. They're able to go and work and actually pursue potentially a green card down the road while building their profile. So that's a typical thing. The steps to do that are very complicated. So that's one example of what you might need. And it's different from someone, say, for example, a case that we have right now is someone who's abroad, who they're going directly to a self-petitioned green card, the EB2 NIW, and they happen to be an entrepreneur, and they're petitioning to come in that status.
How can businesses protect themselves from legal risks when they employ foreign workers, especially in industries with fluctuating visa regulations? Because there's so many moving parts. There's, I'm listening as you're telling me all these little things. I'm trying to remember all these letters, like you said, the alphabet soup,
Exactly.
And there's different things for this and different things for that. It's complicated. So what kind of recommendations do you give businesses to protect themselves when they're going through this process?
I mean, there are the standard processes. I mean, background checks.
Yeah.
It's like you have to know that who you're dealing with is who they say they are. It's a little bit more difficult with foreign workers because you don't always have a lot of information about them, but really checking in terms of their educational history, the history that they present to you in terms of where they have lived. This is all information that they would have to submit in an application. You might ask to see previous applications that they've submitted in terms of jobs. I mean, it's difficult because you can't ask them about, show me your student visa application. You can't do that, because it's really none of the employer's business. But down the road, let's say if you are petitioning for them, you will have access to that. You will have access to all the information. So you have to make sure as the employer, potential employer, that all makes sense. And if so, it's like anything else. If there are gaps or whatever, you have to find out. You don't want to be in a position where there's a conflict, where the employee is asking you to do something for them that goes afoul of the rules that you're supposed to be operating under. And this is tough. I mean, what can happen, say, for example, you have a layoff, you might have an employee might say, well, you can keep me on the payroll and tell, USCIS, that I'm still employed. That's the sort of thing, get some advice, but follow your gut in terms of, I don't think I really ought to do this.
If it doesn't feel right.
Yeah.
You mentioned before, something I wanted to ask you about. You mentioned about student visas, you can't work. Does that include, you can't even get just like a part-time restaurant, back house job I know it probably still happens, but.
It absolutely does. And unfortunately, if they find out, I mean, because, you're hitting right on something that is a big issue. People they work for Uber, they work in the restaurant. They have to. And so it is possible to get approval while in F1 status for, I think there's on-campus work or something, but it's extremely limited. And it can only be so much. And then after you finish your program, if you go into this OPT, then that has to be exactly the work that you say that's going to be. It can't be anything else. So it puts people in a very difficult position. You kind of have to just bring sacks of money with you.
Yeah. Generally speaking, most people don't have sacks of money laying around.
No. And then the other thing is, it's really hard to get approved for these programs as a way to help you get to the U.S. And I think that's something that definitely in the new administration, these are going to be even harder to get.
Yeah. What kind of punishments or consequences could businesses face for non-compliance with immigration laws?
So there are fines, around, the sort of things that we're seeing right now, not keeping accurate records with these I-9s, for example. They have daily fines for that. You could actually potentially be shut down. You don't see that very much. But in some industries, you do see sort of layoffs around trying to clean up around that. So that's primarily it. In the area that we are focused in, it's rare with the self-petitioning or the entrepreneurial side, but with the employer side, with H-1B, there are site visits that they can do and check to see if you did the correct posting of jobs, where there's another process where you can post a job and then sponsor someone for a green card. If you have layoffs in that situation, sometimes those can be taken away. It's really serious if your agency, for example, let's say you're working with an agency, not so much as, say you have programmers that are coming in and working for you through an agency. If it's seen that you were involved in any kind of wrongdoing, any kind of fraud that agency was doing, then that can also cause legal issues for your company. So you really have to it's sort of a know your customer thing, or know your vendor. Know your vendor is actually really what it is.
Yeah, you're right. What is the most common mistake or violation that you see businesses make?
Not checking, not maintaining status. So someone who really shouldn't be employed being employed. That's the most common thing. And sometimes it's not intentional. Sometimes, the employer doesn't know, but unfortunately, if there's an audit or if there's an investigation, it can come back to haunt them.
Is there any sort of consideration, like if whether they knowingly did it or non-knowingly did it, as far as what the penalty would be?
Not much.
Yeah, I figured as much. Kind of hard to separate those two from a legal perspective.
Well, and then keep in mind, it's civil ultimately.
Right.
So it's like, Department of Labor, or although, I think, some of the I-9 stuff, there may be criminal, most likely a misdemeanor potential there. And mostly that's fines. Generally nobody's going to jail for that. If it rises to the level of fraud, then we could be talking about serious stuff.
That obviously makes it bigger. Yeah. For entrepreneurs looking to start a business in the U.S. while navigating immigration law, what advice do you give them to ensure their immigration status as well as their business venture are secure?
The key thing from an immigration law standpoint is keep track of dates and requirements. And when you come into the U.S., you're issued what we call an I-94. The I-94 has a date up to which you are authorized to stay. And then, of course, this is for the non-immigrant categories. But you have to be aware of how your visa approval, let's say, for example, just H-1B as an example. So your H-1B goes to 2027, but your authorized stay is before that date based on some other factors about, maybe you were out of the country. So that's the date that you have to keep track of, is that authorized stay. It's similar to, some people have 10-year visitor visas. Well, every time you come, you only have 6 months that you can
Mhm.
stay. So, I have this 10-year visa. I can stay for 10 years. No, you can't. And
It doesn't work that way. Yeah.
yeah, people know that. And that's just as an example for these other situations where the intricacies, there are times where you may have, well, in the layoff situation. So when you're laid off, it's the earlier of 60 days from the day you were laid off, or your duration of your status, your approved status. So it's your responsibility to know when that 60 days is. And it's very technical. It's like if your flight leaves on that 60th day, you're a 1-day overstay. Fortunately, the consequences of that are not terrible, because up to 180 days, you can probably reapply once you've left and come back in. But you don't want any overstays. That's kind of the key.
Yeah, that's like the general rule. Don't do it. Just don't overstay.
Exactly. And then over 180 days, you have to remain out. I believe it's 3 years. I'd have to check before you can even apply again.
Yeah. So penalties are harsh for that.
Yeah, very harsh for any time out of status as a non-immigrant. Very harsh. And so I would say there's nothing more important particularly for entrepreneurs, because it's easy to come and then you're in these different statuses and you're like, well, I'm okay because I have X. And it's sort of like the other thing, often you're not even in the status that you might get by having an approved petition, because you have to leave. You can go to Canada. In most cases, it's really just going out and re-entering in your new status. But you have to stay aware of that, because let's say you're just working along in this status, and then you're assuming that when you got a new job, this is the scenario, just so that it makes sense, because I'm sort of thinking all this stuff in my head, and I just want to make sure it's explained.
Scenarios are great. That's the easy way for me to wrap my brain around it. So
yeah. So it's what people call it H-1B transfer, but there isn't really such a thing. It's you file a new petition for a new job. So change of employer. So with change of employer, you're here in the U.S. You get everything's done correctly. You get the new position. So you're just going along thinking, well, I just got my new H-1B. I'm cool, right? Well, technically, no, you're not out of status, because you're allowed to stay, but you haven't activated the new status. So you have to actually go out and then come back through we call it visa stamping sometimes. Go out and you come back through in that new status, and then you're good for as long as that lasts. It's not really like an issue too much if you just stay during that period, unless you want to get into another status and you never activated that H-1B. Because then what will happen is like, well, we don't really have you ever being in that new status that you had the approval for. Like, for example, you have to have pay stubs going from that previous job to the new job. You have to actually show that you worked in that position. So these are the things that employers and employees have to keep track of.
Certainly a lot to navigate. Well, thanks for tuning in to Immigration Unpacked, real legal help for immigrants with Kevin J. Stewart. To connect with Kevin, head to oaklandimmigrationlaw.com. And of course, please be sure to like and subscribe to our channel. Kevin, great having you here. Thanks so much for your time.
All right. Thanks, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.